Okay, so this is the meeting of the Discipline Subcommittee of the Paraprofessional Program Working Group. Oh, actually, you know, we have a couple of other people. Sharon Bashan and Julie Felmuth also have joined this subcommittee. So maybe we should give them another minute or two. I think that Julie said she'd be able to make it to this meeting.
Well, why don't we see if we have public comment, Linda?
Okay, let me go ahead and take roll for now. Oh, good. There's Julie.
There's Julie.
Okay, so let me go ahead and take roll. Bashan, didn't see her. Felmuth.
Here.
Kirkmeyer.
Here.
And Spiro.
Here.
Great, thank you. So let me just see. We have a couple of attendees. If there's anyone who would like to make public comment on the items on the agenda today, please use the hand raising function in Zoom and we'll call on you. Give people a little bit of time. So far, we don't have anyone indicating an interest in public comment. Justice Petro, I'm glad you were able to join us for one of our meetings this morning.
I'm glad I can do this one. I'm sorry I can't do the ones this afternoon.
It's a lot, so that's fine. We appreciate it. Okay, I think we don't have anyone who wants to make public comment, so we can go ahead and get started. I just have a couple of slides that I prepared. So as far as I'm aware, these are the outstanding issues where we left off at the last meeting. The questions had to do with whether the staff adjudicator should be an attorney or a paraprofessional, whether the initial hearing would be just a staff adjudicator or would have a panel similar to what was decided on for the appeals. And then questions about public records, what would be included, and then how long each of these types of records would remain public. And there was also some discussion about the unauthorized practice of law and how that would be managed through this program. And I sent out the statutes and also information from the annual discipline report the State Bar publishes that talks about the current remedies that are available to the State Bar for the unauthorized practice of law. But with that, I'd like to well, first of all, I want to check in with the members of the subcommittee to see if you think there are any outstanding issues that aren't captured here. Okay. So with that, maybe we can just have a discussion about the question about the staff adjudicator. And Leah, you had a chance to talk to the OCTC this morning?
I did.
I don't know if you discussed any of these issues or if it was really focused on the cost model.
I did discuss some of these issues, not the first question, but OCTC certainly had a preference for our option 2 at the hearing level, that it would be the adjudicator versus a panel, and that the panel would come into play only at the appellate level. And when we get there, I can share their thinking on that. They also wanted to clarify in the model if there was going to be a panel at the initial level where it says hearing or settlement conference. They wanted to clarify if there was going to be a panel at the hearing level, was it also contemplated that there would be a panel for the settlement conference, because that was not viewed as optimal. They thought a settlement conference should be handled by one individual, the staff adjudicator. So those are some of the issues we talked about today, in addition to cost.
Okay, and if it would be helpful, I can bring up the model again. If people want to have that, would you like me to share that on the screen?
That'd probably be helpful.
Okay, let me go ahead and do that. I think I'm getting more adept at changing what I'm sharing. Okay. You see that now?
Yes.
Yes.
Good. Okay. I'm getting to learn about Zoom and how it works as I'm doing more of these meetings. So the first question about whether the staff adjudicator would be a licensed paraprofessional or an attorney. What are the thoughts of the subcommittee on that question?
Attorney. Oh, did you hear?
Yeah, we heard
I
you.
think it should be an attorney. I think it should be somebody familiar, because I think it should be somebody familiar with formal decision-making and rules of evidence.
I don't disagree with Ira, but I would say that especially for citations and fines, those hearings are often held by a staff person or the executive officer at the Department of Consumer Affairs boards. And those people are 99% not attorneys. And when you bring an attorney into this process here as an adjudicator against a paraprofessional, you're introducing a real bias situation. I don't disagree with Ira that it should be somebody who is knowledgeable of the law, the rules of evidence, as you know, in an administrative hearing. But at DCA boards, those folks can get good at, and Kim Kirkmeyer can weigh in on this. Those people get good at understanding the violations, the evidence that's needed to prove a violation, and the remedies. They don't need to be an attorney to do that, especially when it's at a citation and fine level.
Yeah, I would agree on the citation and fine level. It's almost like you might need to separate the two types of activities that they would do, because I do think that the staff level can definitely at least hear the informal conference portion of a citation and fine. That should be done at staff level. And then maybe if they appeal it, like, in our state, it would then appeal to the administrative law judge. Maybe at that point, then you would appeal it to that next level of adjudicator. But at the first level of an appeal of a citation and fine, I agree. I don't think it needs to be an attorney. Or actually, for that matter, I don't know that it needs to even be a paraprofessional for citation and fines.
Just to make sure I understand, are you saying it doesn't need to be a paraprofessional or an attorney to make the decision as to whether or not citation or a fine is an appropriate disposition option, or to decide on the level or the type of citation and fine?
Both.
Both.
Well, I'd like to add something if it's all right. Now I'm going to argue against myself here, because when I heard Julie and Kim discuss that the non-lawyers become good at the procedures and at the evidence questions, which aren't, they're not the evidence rules that you'd have in court. It's more like what's reliable evidence. So when I hear that non-lawyers become good at that, and that there's a bias, could be by lawyers against paraprofessionals, Now I'm thinking that a non-lawyer, now I'm thinking the non-lawyer should be able to be a hearing officer, if that's, what are we calling them, hearing? An adjudicator. If they have experience in litigation or and evidence, or get a course in it.
Okay, so let's just look though at the chart. The way where we have citation and fines placed kind of structurally is in OCTC as part of the investigation phase in the charging decision process. So that necessarily, unless we are going to be saying to OCTC, you don't have to have an attorney doing that. That process is going to take place in OCTC, presumably by an attorney, right? And or maybe an investigator in that office, not a separate sort of staff adjudicator or staff person outside of OCTC as part of the green boxes above. This would happen at the OCTC level the way this is structured now. Does that change your thinking, or do you want to change the way this is showing up in the document?
So are you saying that the citation and fine would never get to the green box? So if they appealed the citation and fine, then would it go into the green box? That's the question I have.
I don't know. I think
Okay.
it can't be that it never goes into the green box, that maybe it does. Maybe the disposition options, these aren't, so stipulated discipline would have to get approved up in a green box phase. And NDC would take it formally into the green box. Diversion, I don't know. We haven't talked about whether that would need a green box, but presumably not. Need the green box or not. And then, so citation and fine, I think that's TBD. Right now, on the attorney side, the agreements in lieu of discipline do not go to the equivalent of the green box.
At DCA boards, if a licensee wants to appeal a citation and fine, it goes into the green box as such.
They have two options. They can do an informal conference, which is at the staff level, and it would be dealt with the appeal there. That's their first level. And then or they can do straight to an administrative law judge into the green box. But most of them will appeal it at the lower level first. And then if they don't like it, they still have the option to go into the green box. It's like a two-step almost, unless they want to skip the first step.
I thought that if they wanted to appeal a citation and fine, it goes to the executive officer or his or her designee, which is generally a staff person.
So at least for
50%
medical,
not a lawyer.
yeah, so at least for medical board, the first step is of their appeal is to request an informal conference. It could be, or they can appeal it directly to an administrative law judge. It's either or.
Oh, okay.
Yeah, and in the first step, then it is it's the executive officer, or it's an individual, staff member, chief of enforcement, something like that. But then they could still, even if they don't like that outcome, they could take it up to an ALJ. And I don't know, I think that's pretty much standard for most of them for that informal conference step. But Leah's right, because even the stipulated discipline would go up to a final outcome, right? Like a final approval.
Yep.
I guess, Leah, I think I'm having a little bit of a struggle for the decision for first question based on what you said about the second, because I would tend to agree with Ira that it needs to be someone that knows rules of conduct and everything for a staff adjudicator. But I also completely agree with Julie, that's going to completely put in conflict, potential bias issue for the individual and everything when they go to that level as a paraprofessional. But yet at the same time, I don't know if you want a paraprofessional being the adjudicator either. So I'd like to hear why they don't want to have a hearing panel at that point. Because I think if you had the hearing panel at the hearing and settlement conference point, that would actually be kind of the best thing to absolve all of the conflict issues.
Well, I think their concern was more like logistical, because only the staff adjudicator will be on staff. They're really worried about lack of availability, not being able to schedule. It was more administrative concerns, not substantive.
Okay.
I mean, so, and a concern about people being volunteers, which we said, well, they're not exactly going to be volunteers. They will be compensated, and wanting to make sure the compensation was sufficient to address some of the, issues that come with pure volunteers. So that was the concern. So it's not substantive. Although on settlement conferences, it was substantive, that they didn't think that would be an efficient process at all to deal with 3 people in a settlement conference.
Yeah, and I would agree with that. I think the settlement conference should be the one person, and then it's still going to go up to that final review and approval.
Yeah.
Well, then we should make a distinction, I think, between hearings where there's an adjudication and settlement conferences.
Right. I think we're going to have to break it out of the box.
And also on the logistical problem, I don't think there'll be one in this, because remember the paraprofessional and public member, there are only going to be a few of them. And they're going to serve for a term of a year or something like that. It's not like we'll have dozens of people we have to coordinate with.
Yeah.
But that's also their concern, right? Because of just scheduling.
Right. And I think, I don't know, in a way we have to see how it goes. If you maybe set your annual calendar in advance, I don't know how that would work procedurally, but you're sort of part of your stipend you're giving people is to keep their calendars open.
Yeah.
2 days a month or something like that. And then you have, I have to think there are creative ways to try to deal with this issue. So it sounds like you want to stick with the panels at the hearing and the appellate level. And then if that's the case, Kim, where are you leaning in terms of the staff adjudicators, an attorney, a paraprofessional?
If it goes to a panel, I think it can be an attorney. I don't have a problem with it being an attorney. Julie, I have a question for you. Based on if it's, the conflict issue, if we did have that adjudicator, and I know there's issues with having that, paraprofessional board be the second review, but if they provided that second review, kind of like our boards do, which I know, there's discussion on both sides of that. But if they were that second review, would that kind of absolve some of that conflict issue? Because then it would be being reviewed by individuals within their profession and public individuals as well.
It would help. Yeah, it would help.
Yeah.
I'm sorry, I had to step away. Is Sharon on this call? Because you know what?
You did join.
She's not on the
She's not- Okay, she raised an issue at the last meeting when I was talking about the State Bar Discipline Monitor Project. And she raised the issue about training. And I'm so sorry, I had to step away for a minute, so I don't know if you already talked about this. But even if it were a staff adjudicator at the hearing level, that person would obviously need to have training in the rules that apply in an administrative hearing, the various kinds of offenses for which a citation and fine is appropriate, or versus some other bigger form of, sorry, I'm just, Bob just got home from the hospital yesterday, so I'm kind of whacked out here. So yes, Kim, in answer to your question, I think the use of a panel at the appeal level would help the bias, probably help the bias perception if the hearing, the staff adjudicator was either an attorney or a paraprofessional. But that adds to the cost of the process.
For my 2 cents, I think this would go down better with some of the folks that are more skeptical of the program if the position was an attorney, for better or for worse. And I think having the paraprofessional and a public member and introducing that model does mitigate against some of the, the concerns. So that's my 2 cents on the issue.
And I almost wonder if you did have a panel, if it would cut out the review recommended or needed by that board. Because if you had a panel with, each representative, would you need to have it reviewed by the board still?
Or just go straight to the Supreme Court?
Yeah. Just not to Supreme Court, they'd still have appeal, but on that first step there, how we said like the hearings and settlement conferences, those would be like over reviewed by a paraprofessional board. If you had it as a panel, maybe the board doesn't come in unless they don't like the outcome. I'm just wondering if we had a panel, if there is a need for that second level review by the board. I mean, that's how we do it with our individuals. But we don't have a panel either. We just have a administrative law judge, one individual.
Yeah, that looks awfully redundant. We got the board reviews, and then whatever happens there,
Yeah.
There's another appeal. That doesn't seem needed.
Yeah.
So I think it would, if there is no appeal, it would go from the hearing to the Supreme Court.
Yeah.
Level to the Supreme Court.
Yeah.
Or are you saying that what's showing up as the bullet should be thought of more as the initial appeal?
Like move it up.
The bullet at the bottom of the first green box.
I think Kim is saying move the bullet at the bottom of the first green box up to initial appeal. So whatever decision comes out of the appeal has to be approved by the board. Is that what you're saying, Kim?
Yeah, or put them somewhere in the middle. Maybe you don't have an appeal. Maybe the appeal is to the board rather than either another adjudicator and another hearing panel.
I'm wondering why we need to have any appeals to the board, any review by the board. I mean, we're setting up a procedure and thinking pretty carefully about it for appeals. And then why have another procedure for review if nobody appeals? There's still the safety valve of the Supreme Court at the top. But regardless of that, why have another? I don't see the need for it.
I think, Ira, that came from me when we were talking about, looking at it from the perspective of how we deal with them here with the department. And it is for us that ALJ or even a settlement decision, those always will go through this board review, because then you get individuals within the profession and the public making sure that it meets consumer protection. That's kind of how we have it. And I think that's why I put it in there.
Just to give my 2 cents, I think and this is my 2 cents, the court will likely be reticent to to allow themselves to be the first and only level of review of a hearing conducted by the panel. I think there needs to be some level of interim review before it comes to the court.
Yeah,
I agree entirely.
yeah, that makes sense.
You mean even if there's no appeal, Greg?
Well,
So-
if there's no appeal, so what happens on the lawyer side if there's a recommendation for suspension or disbarment? Those are the only types of discipline cases that come to the court. The recommendation comes to the court and we hold it to see whether or not a petition is filed either by OCTC, who may not be happy with the outcome in terms of the level of discipline, or from the attorney, the respondent. And if there is no petition filed, the recommendation of the state bar court automatically becomes the order of the Supreme Court. And then the court conducts audits, of those cases as well, even when there's not a petition filed, just to make sure that the state bar court is properly applying the rules and the standards for attorney sanctions and whatnot. But that's the procedure. So if nobody asks for an interim appeal, then the recommendation comes to the court, and the order of discipline, if it results in suspension or disbarment, will become the order of the court. Private reprovals, public reprovals, that does not need to come to the court. The state bar court is authorized to administer that discipline by itself.
Greg, can I ask a question?
Yeah.
Does the court require that the appeal, that an appeal was made to the appeals division of the state bar court before an appeal can be made to the Supreme Court?
Yes, there's an exhaustion requirement. You can't skip the review department in the state bar court and go directly to the court. Now, the only difference being if you're a complainant that has complained about an attorney and OCTC, and that's what that blue box to the right is. If OCTC decides to dismiss the complaint or not file charges, then the complainant has a right. We call them Walker petitions, based on a 1950s case, I believe. The complainant has an opportunity to come directly to the court and make an accusation directly against the attorney. And essentially what they're saying is OCTC abused their discretion by not proceeding with the disciplinary proceeding.
What does CRU mean there, folks?
Complaint
That's the
review unit?
Like review unit.
Oh,
That's within OCTC. So if
It's
OCTC,
actually now within OGC. It's moved.
I'm sorry, OGC, you're right, OGC. It used to be in OCTC, we moved it to OGC, so that it'd be separate. So that's the Office of General Counsel. And if OCTC decides not to proceed with disciplinary charges, the complainant has an opportunity to appeal that, to ask for a review of that decision within the Office of General Counsel's Complaint Review Unit. And again, if the complainant wants to proceed to the Supreme Court, they need to exhaust that avenue of review as well before they come to the court.
Greg, did you just say that the complaint review unit is within the Office of General Counsel?
It is within the Office of General Counsel.
Okay, so it's not in OCTC.
It used to be,
Okay,
but we moved that out so that there would be a separate division within State Bar reviewing those complaints, those decisions to not proceed with charges.
I think I asked this, Greg, once before, but how many goes through that process? Do you know, like in a year?
We'd have to look at the annual discipline report. I'm not sure if it's in the annual discipline report, because that really focuses on complaints prior to charges being filed.
Okay,
It is in the annual discipline report.
Is it? Okay.
I
So
think I have that.
yeah, I'm not sure what the exact number is. We get a fair number of Walker petitions, accusations. I would say on every conference we have at least 5 or 6. Very few of those go back though.
Is it in the appendix, Linda?
I'm looking for it now. I think we moved it from the appendix in the 2019 report, but I should be able to find it very quickly because I'm quite familiar with this document.
Okay, I see it. 1,601 complaints received in 2019. Or the
So
number.
if I have my math right, usually it's about 16,000 complaints filed, so that's about 10%.
Yeah, and then 14 were reopened due to new evidence and 22 reopened due to error in closure. So about 1%.
And I'll say that the
So
court,
those are cases that went to the complaint review unit, not, I don't think that the Supreme Court remanded that many for
No.
review.
No, I was talking about crew.
yeah, she's talking about CRU, but so I would say, I'm going to guess just based on personal experience, we probably grant a handful of Walker petitions each year and send them back and ask, either ask OCTC to continue investigating or strongly imply that that charges should be filed.
One was sent back in 2018 and one in 2019.
Oh, so even less than that. Okay.
Yeah.
But we do look at all of them, and there's a memo written on each.
Okay, so I think where we are is retaining the panel at the hearing level, splitting out settlement conferences, and those will be handled by the staff adjudicator. Retaining the structure of the hearing, I think, the hearing decision going to the board before it goes to the Supreme Court, right? Okay.
Yes, yes. And that also ensures that, and we talked about this a little bit at the last meeting, at DCA boards, they have a document called disciplinary guidelines. The bar calls it something else. I don't know what it is, I forget. But it's the disciplinary guidelines are intended to assure some level of consistency across time, across geography, across various decision makers. So the board adopts those disciplinary guidelines, or would, and the board can ensure that any given sanction is consistent with those disciplinary guidelines.
And they're called standards for attorney sanctions under
Oh,
the.
thank you.
And the court looks at those as well, not only the application of the standards, but as well as looking at prior cases. So normally what we ask for from the review department especially is some analysis of how those standards apply here and how this case fits into the to prior cases in terms of comparing the type of conduct and the type of discipline that's meted out.
Thank you.
Just a quick question. If a case is appealed, does the appeal also need to be, the decision of the appellate panel also need to be approved by the board before going to the Supreme Court, or does it go to the Supreme Court?
Directly to Supreme Court.
Okay, so no board at the appellate level. Linda, have we gone through I can't remember the question, all of the questions.
No, so the final question that we had, and I can bring this back, is hold on a second. This question about what types of discipline would be public records and how long they should remain public, and if it would be different lengths of time depending on the type of discipline or alternative to discipline.
Well, can I, it just occurs to me that there's another, sorry, another issue that we haven't resolved. Maybe we have, I don't think so. Whether the appeal, the top green box, is de novo or not.
Well, I will tell you on the attorney side, review department does a de novo review of the hearing department's decision. They do, obviously on credibility determinations, they defer to the hearing officer just as they would in any sort of civil case on review, but it is a de novo review by the review department and de novo review by the Supreme Court as well.
Oh, you know what, I should, there's another distinction in there about what is de novo. Like when you appeal from the small claims court, it's de novo to the Superior Court, but it's de novo, really, really de novo because you call witnesses. Partly because there's no record in the small claims court. So what would it be here? Relying on the record, but well, what would it be? What do people think? I don't know. I mean, we don't have to take this now. I went out of order. I just wanted to flag it for later. Maybe we should do the public records before we do this.
So on the attorney side, again, the review department does not call witnesses. There is oral argument, and there's a opportunity to present written argument, obviously, as well. And it's a review of the administrative record.
Oh,
That's similar to us as well. If we appeal, I mean, if somebody appeals and it's going through that process.
so it's de novo only in the sense that you defer to the,
Yeah, you don't retry the case.
even on paper, you don't retry the case.
Right. Well, I mean, you're looking, so there have been cases where there have been cases where the credibility determination of the hearing officer, even though there's deference, has been reversed based on the testimony. I'm trying to think of an example right now, but it's eluding me. But they will review all the testimony as well and make determinations based on that as well. So it's de novo in that sense, but they're not going to recall witnesses and do follow-up questions that weren't pursued on cross-examination or anything like that.
Okay.
Do you
So
have
where
any
should
more on that, Ira?
Hmm?
Did you have a follow-up thought?
I think we ought to decide, maybe we kind of have decided without saying so, that it'll be the same type of review as happens in the attorney discipline system. It sounds okay to me. I'm not sure. I haven't thought that much about it.
Julie or Kim, any thoughts?
No, I'm a little confused just by something Greg said. Or maybe it was Leah. Where we seem to be here is that if there is a recommendation by OCTC coming out of the investigation, for example, for a citation and fine, if the aggrieved person wants to appeal that, they can request a hearing or a settlement conference, and that would be in front of a panel. And if the outcome there is still unsatisfactory to the licensee, it would go to an appeal before the board. Is that correct?
But it must not have been for me because we don't have citations and fines for attorneys.
Right.
So that there's no comparable, there's no nothing comparable in the attorney discipline system to what you're envisioning there.
So I think
Let's say
but I thought the appeal was with an appellate panel, not an appeal before the full board. I thought the appellate box is the second, the second box up.
yeah. Where does the board come in then? Nowhere?
On the attorney side?
No,
Oh, okay.
on this thing.
This, yeah, the recommendation.
So the board, my understanding, what we just said is the board has to approve the hearing decisions that are not appealed, right? But the board does not approve appellate decisions. Those go straight to the Supreme Court. I thought that's what we just said.
That's what we said. So I understood.
Hmm.
I actually thought we were changing it too. I thought we were putting them into the next level. And because if there's a panel in the hearing and settlement conference, and if everybody's okay with that, I don't know if you need that board review. I don't know if it's just adding to it. I don't know.
But remember, we heard from Greg that the court wouldn't want to be the first entity to review.
Right.
So I thought that's why it was going to go to the board before it went to the court.
what
Oh,
I
I
thought.
forgot your court approves all of the actions.
So does that mean that the initial, this appeal isn't to another hearing, an appeal panel? It's to the board, directly to the board?
No,
No.
So I don't understand, because what's being appealed to the board?
Nothing.
Oh, I thought you were saying about a
Yeah,
board.
I thought we were at some point in this conversation, and I had to step out, so I'm sorry. I thought we were moving that bullet in the first green box up to the second green box entitled Initial Appeal. And I thought the board would handle that as opposed to either of those two options. And I could be wrong, but that's what.
I don't think so. We did
No.
talk about moving that bullet, but I think we decided to leave it where it is because of as a filter before the first box gets to the Supreme Court, first green box.
So maybe one question is right now in the red box. It says appeals and entry of final orders. Maybe, unless we're going to change this again, appeals is inaccurately there. This is an entry of final orders coming out of the hearing level and settlement conferences. Things that are not appealed. The board enters the final orders. Does the board, I don't think the board has a role with respect to initial appeals.
Huh?
The appeals go from hearing to appeal to the Supreme Court. It doesn't get approved by the board. But hearing and settlement conference decisions would get approved by the board. That's the way I've understood our discussion.
Me too.
But Julie and Kim, that sounds like that concerns you. And back to citation and fine, just to make this even more complicated, I think there's still a decision, there's still discussion that needs to be had about like what is within OCTC's purview to do on their own versus what needs to go up into any green box. Has to versus the paraprofessional wants to because they don't agree with what OCTC's recommending. But where there's an agreement, for example, on a fine, does that need to go up anywhere?
I would say no, not what my thought process is for a citation and fine. I think if the OCTC decides that there is a need, there's a violation there needs to be a citation and fine, that citation and fine could be issued to the individual. If there's agreement with it, I think it's just done at that point.
Yeah.
That'll save staff time and reviewer time and everything. And then if they appeal it, then at that point, even if they appeal, kind of to what Julie was first saying, was even that, I think that could be done within staff at OCTC to hear the informal conference, because then they can hear the other side and review the evidence and see if that overturns their decision. And if it doesn't, then at that point, it could go to the green box. That's just my recommendation on citation and fines. We'd have to carve out almost.
Okay.
Does that make sense?
Would you repeat it, Kim?
Yeah, so I think the OCTC, they're gonna have enough information and knowledge about the case to be able to say, okay, there is a violation here. And then what they would do is they would issue that citation and fine to the paraprofessional. If the paraprofessional wants to appeal that, they could appeal that even within the OCTC to hear the evidence that they have as to why they don't believe that there was a violation. And if they uphold that, then the individual would be able to go to the green box and appeal it to that next hearing level, hearing panel level. But
Who
if
is it
they-
with, go ahead.
I was gonna say, but if they agree to it and they just pay the fine, then it would just be done at that lower level.
Yeah. Unless the victim, if you will, goes to this CRU thing. But what happens, who is it in OCTC that would do the
Yeah.
review?
Yeah.
Yeah, I don't like the idea of OCTC reviewing its own decision.
Well, and just channeling them, I don't think that they'll want to, just because of the workload.
Although that's how we do it, Julie, you know, at DCA, we review our own decision and the citation and fine. A lot of times it's the chief of enforcement who signed off on that citation. They'll have the party come and present the evidence, and then they, in that informal conference, and then they finalize it. But I mean, I understand if OCTC wouldn't want that role, then we wouldn't want to put that there, but.
I think it's okay so long, because the paraprofessional does still have a right of appeal to the first green box. First green box? Is that
No.
right? Or a second?
The first green box.
All right.
But Leah, if you don't think they would want that role, I mean, maybe then it's just they can issue the citation and fine, but then the request to appeal it would go to that first green box.
Yeah, I think so. Again, I'm channeling them, but
Yeah.
Yeah. But I fear that I got us a little bit off course, because the big issue was this, like, hearing and settlement conferences, the decisions have to get approved by the board before going to the Supreme Court, if not appealed. Appeals, I said what I thought. I think it aligned with Ira, but I think it was different than, Kim, what you were thinking, or Julie, you were thinking.
Well, may I say, we don't have to be bound by what we did a half hour ago.
No.
And I guess I forgot, Leah, that the Supreme Court actually acts upon all of these as the final.
Well,
So,
let me just clarify that. The Supreme Court acts on all recommendations of disbarment and suspension. So the way to think about it is anything that affects the active license of a licensee, their ability to practice, will come to the court. But reprovals, lower levels of discipline do not need to come to the court unless the respondent appeals it.
okay. So like a probation, that wouldn't go to the Supreme Court.
No.
Okay. All right. So that is a little bit different then. And so, Greg, you were saying that the Supreme Court wouldn't want to see anything from like the hearing or the settlement conference that hadn't had some form of approval first?
Some sort of review, I believe. I
Okay.
mean, that that is I'm channeling the court right now, but they do benefit from having that interim level of appellate review, and I'm sure they would want to continue to have that.
So sorry, can you just walk me through one more time on regular attorney discipline? So if it goes to right now, who does the hearing and settlement conference? Who does that? I can't remember.
A hearing judge. There's a panel
Okay,
of hearing judges.
State bar court judge.
okay,
Right.
so it's a state bar judge, if they make a decision and it's for a suspension, does that have anything before it goes to the final order if it's not appealed?
Well, if nobody appeals it to the review department, which is the interim level of review at the state bar court, if it's a suspension of license, it does come to the court. Now, who would appeal that? Either OCTC may try or the respondent, but the failure to exhaust at the interim level will mean that it's just an order from the court. It's almost a ministerial function by our court to issue the order of suspension, because only the court can suspend a law license or disbar a member, a licensee of the state bar. So there really is. I mean, if the state bar court makes a recommendation, we call them recommendations, a recommendation of suspension, either OCTC or the respondent has to appeal to the review department before having an opportunity to seek Supreme Court review. Does that make sense?
Yeah,
If the hearing judge orders disbarment or suspension, and the respondent does not appeal, that order / recommendation still goes to the California Supreme Court, because only the court can discipline somebody, an attorney's license.
Right. It needs to be an
It's a ministerial thing because the respondent did not appeal.
correct.
Okay.
so I guess back to my point of the board, is that, again, I just kind of go back to, if there isn't any form of appeal, is there a need, if it's a panel, a hearing panel for the initial hearing, if it's a panel that hears this matter, does it need to be reviewed by the board if there's no appeal?
As I understand it, it does, because the Supreme Court doesn't want to
No.
get things without a review.
Well, there's no need for review because nobody appealed. So let's take, for an example, a hearing that ends in a public reproval, and nobody appeals that to the review department within the state bar court. That order from the hearing officer becomes the order of approval. That's how the discipline is, and we never see those cases.
We, the Supreme Court. Right?
Yeah, yeah. The court never sees those cases.
Well,
I'm sorry, go ahead.
what if the decision in the green box is to suspend or disbar?
Yes, we see them in the sense that all recommendations for suspension and disbarment are transmitted by the state bar court directly to the court. It sits in our clerk's office, and we await, I think it's a 90-day period, await any petition for review filed against that recommendation. If after 90 days we get no petitions, then the order of the state bar court becomes the order of the Supreme Court.
Well, then in the paraprofessional system here, I gather what you're saying is that well, I conclude from what you're saying that the dot on recommendation must be approved by paraprofessional board would not be needed. Because in an analogous situation in the attorney system, there's no additional review before it gets to the Supreme Court.
For certain levels of discipline. Yeah, that's right. That's right. It's just the state bar court is authorized to discipline, to administer those lower levels of discipline itself without it ever coming to the Supreme Court. Anything that arises to the level of suspension or disbarment does come to the Supreme Court. It has to be an order of the court because it affects their license. It affects their ability to practice.
But that interim level of review of if there is nobody appealing it, the Supreme Court will impose that without the equivalent of this approval by the paraprofessional board. That would be acceptable to the court if we eliminated that step if there were no appeal. Is that correct?
That's correct. As long as, so the one other caveat, yes, that's correct, Linda. The one other thing I will say about those cases that the hearing officer recommends suspension or disbarment that come to the court and no petition is filed, the court, as part of its supervisory duty overseeing the state bar, will do random audits on those petitions just to make sure that the state bar court is correctly applying the standards for discipline and the standards for attorney sanctions. And there have been occasions where we have sent back cases where nobody appealed because we found that the state bar court was deviating in a way that was concerning to the court. But that's part of our own supervisory process. That's not part of the appeal process whatsoever. And so those sometimes those decisions are looked at, but it's not part of this flow chart that you have here. That has more to do with us supervising the state bar in terms of its disciplinary function.
Well, now I'm gathering again that if the first green box, the lower one, is a hearing as opposed to a settlement conference, then there's no need for the bullet there. Recommendation must be approved.
Yeah, sounds like we're back to doesn't need to be approved, hearing or settlement.
Yeah.
But what about the settlement conference?
Yeah,
That has to go to somebody,
someone.
the board, a hearing panel.
The settlements have to be approved by a state, and on the attorney side, approved by the state bar court,
Yeah, they do.
stipulations and settlement.
Could they be approved by the panel, the
Yeah.
hearing panel?
I don't see why not.
Well, that's where it's taking place. Isn't
I mean,
that-
I'm just throwing that out there.
Yeah, I don't see why not. We don't even know what this professional board is going to be. So I'm reluctant to say, let's have them review something. We don't even know what it's going to be. We know what these others are going to be.
We're gonna focus on that at our next meeting,
Yeah.
our co-working group. We're gonna get into it.
And the only reason I'm really saying that is it just seems duplicative to me to have a panel that's made up of, if it was one person, then that'd be different. But if it's a panel already made up of, a mix of both, an attorney, a paraprofessional, and a public member, which is kind of what the boards really, that's, why you have them. And that's why they review any decision to make sure that it meets the disciplinary guidelines or the standards. If they're doing that at the hearing panel, I just don't know what the benefit is of having another level of review at that first step. That's just my question.
I agree.
So Julie, where are you with this now?
I'm completely confused. I think I'm confused because I know both of these systems so well. And the bullet in that first green box, hearing and settlement conferences, the bullet recommendation must be approved by paraprofessional board. At DCA boards, at 90% of DCA boards, disciplinary matters are, and settlement, the stipulated settlements are reviewed and approved by the board. And at the state bar, the board of trustees, which is the board, has no role in any of this disciplinary flowchart, none whatsoever. So that's what's confusing me. And I'm trying to envision a flowchart. I'm not sure what I'm trying to envision. A flowchart that's consistent with the state bar attorney discipline system or the DCA licensee discipline system.
So on the attorney side, settlements and stipulations as to facts, conclusions of law, and even levels of discipline are negotiated between OCTC and the respondent, and then approved by the hearing officer in the state bar court. So that's how that works. So if you're going to involve the hearing officer or this hearing panel in the settlement negotiations, I'm not sure you need anyone else to approve it if they're already involved.
And Julie, I'm actually moving outside of both in what we're recommending. I'm saying, if you had, because for us, and the reason I'm saying that is because for us, we just have either like the executive officer and the AG that is working on the settlement, or we have an ALJ, one person issuing a decision. So then it goes to the board to really be like, okay, I have a mixed group of individuals looking at it. But if we've replaced that sole person with this 3-panel that has all representatives of who you would want, which would be an attorney, which would be a paraprofessional for their viewpoint on the issue, and a public member, if you have all of that, I don't know that you would need it to go to a board. It would add time and expense that you might not need because you already have a panel of individuals looking at it. If we had gone with the staff adjudicator, then I would say, no, somebody else needs to look at it. But so that's where I'm coming from. That's why I'm straying from what DCA even does.
From
as
both.
well. Yep, from both. But then the question then becomes is, what's that appeal look like? Would it get appealed to the board, or would it get appealed to a second level of a different hearing panel?
The way this is set up, it's a second hearing panel, isn't it?
Right.
Okay. I hate to say this, but I will, because others might. Does it seem odd to anybody that we have a hearing, the first green box, we have a particular type of panel, we've said what it is, and then the appeal goes to the exact same type of panel?
Wouldn't that only be true if you're picking option 1 in both boxes?
I think we are, though.
Okay.
The same type of panel, presumably the paraprofessional and the public member will be different.
Different people, right.
Yeah.
No, I think the adjudicator is going to be different too. Sorry.
Julie, what are you thinking?
I didn't know we were going with option 1 on both green boxes.
Yeah,
That might have been when you were out
might
of the
not be
room.
necessary.
I can see one answer to my question, which is that, let's see, what was it? That when you get to the second, the people in the first green box are actually hearing the evidence. They're involved, very hands-on. No, the distant difference is that they're hearing the evidence. The witnesses are before them. and they get maybe somewhat invested in what they did right there. And then the second green box is not doing that. They're reviewing a written record. And it's an opportunity for maybe a more detached view of it. Maybe that's good or bad, but. Well, here's another answer. If you're going to have discipline against somebody, at least serious discipline, wouldn't you want two panels to say yes?
And according to Greg, the court would want that before it gets an appeal.
I don't know if the court would want two panels. I think the court would just like two levels.
A review, yeah.
Level and an interim review level.
Yeah.
Two levels to be available, but somebody may not avail themselves of those two levels.
Right.
Yeah.
And the model with the two panels at both the initial hearing and the appeal requires having two different staff adjudicators. If the initial hearing was just the staff adjudicator and required approval by the board, and then you had a second hearing panel, I mean, then the appeal would just have the panel, and that would only require one staff adjudicator.
Yeah.
If we didn't want the same, which is what I'm hearing, one option would be, so just go with me here. This one would be a little bit off. Here's a second option. We could do the staff adjudicator in the first box in the hearing and settlement conferences. It could be an attorney, because there's reason why you'd want that to be an attorney at that point, hearing all of the evidence and knowing the rules and laws and everything. And then it could be then at that point, then maybe that's where you pull that paraprofessional board in, because then you'd have individuals from all of the parties reviewing it. And then it'd almost be similar to what we have here. Then you'd have that paraprofessional board review it. Their final, if no appeal, goes to the court. So now you've had two layers of review. If it is appealed by either side, then it goes to a 3-person hearing panel in that initial appeal. And then that outcome either holds with no appeal or it goes to the Supreme Court. So that's another option we could do if we don't want to do the same thing in both green boxes.
What is the substantive or philosophical or practical problem with doing the same thing in both boxes? Is it just because it's not how things are usually done? Like usually you'd have a different construction of your appellate body?
Seems, but just right off the bat, the issue of having to have two different staff adjudicators.
Right.
I think that's a logistical problem and maybe a cost issue.
Maybe, but they could be 0.5 FTEs each.
Well, what the problem with it that I first saw is that it sounds like it's just a second trial. In other words, let's see. Yeah, you take your shot at the first one, and if you don't do well there, you go to the second one, and they're really pretty much the same proceeding, except one has live evidence and one doesn't. But I don't know, now that I think more about it, it isn't much of an argument in the way I'm thinking of it right now. Maybe I didn't even say it very well.
And I don't actually have a problem doing them the same. I was just offering another option for those that do.
Yeah, I'm trying to think of. Yeah, there's arbitration systems where that happens, where there's 3 arbitrators and then the appeal is to another 3, I think.
Okay.
What if you had on the first green box, hearings and settlement conferences? As Kim said, that could be done by a staff adjudicator who could be an attorney. And if the result of that process is disputed, it could go to the paraprofessional board, who would make the final recommendation, which would need to be appealed to the Supreme Court. So that way you don't have 2 panels. So that initial appeal box would be the board. Although you're right, we haven't discussed who those people are.
Did you say the first green box would be just a single adjudicator?
Yeah, that's what I said, but
Yeah.
yeah, a single adjudicator. It's kind of what Kim said, except eliminating the appeal after it is reviewed by the paraprofessional board.
I think,
The board would handle the appeal is what I'm
right.
saying.
Well, it wouldn't, but the single adjudicator obviously is not going to have a colleague, if you will, of the paraprofessional on it, because it's not a panel. And since that's the one that actually hears the evidence, I think I'm in favor of having a panel there.
So if we have the board handling the appeal prior to anything involving the California Supreme Court, Ira would prefer a panel at the hearing level. Is that what I'm hearing?
I'd prefer a panel at the hearing level in any event.
That is actually hearing the evidence. Yeah.
Yeah, I think it's fair to the paraprofessionals.
Ira, would you change that opinion if that appeal, the type of appeal, the way it would happen with that second level with the paraprofessional board, if they were allowed to, they'd review the record, they'd review the evidence, and they'd review written argument? If they were reviewing all that, I know they wouldn't be hearing from witnesses and everything, but if they were reviewing the whole record, would that change your thought on that? Because then you would have paraprofessionals, involved in that decision-making process.
It seems more fair, but I think I'd still prefer a panel. That's just my opinion. And that was not my opinion, like at the beginning of this meeting or the last meeting.
Can I ask Julie why you're trying to change it?
Me?
I'm trying to figure out what problem we're trying to solve right now. I get like maybe we'd have to have 2 different staff adjudicators.
Yeah, that's kind of what I'm getting at is that the cost and burden on the bar staff to produce 2 panels, one for the hearing and one for the appeal. And I'm trying to have a role for this board. So my thought was, and I can go with Ira, you have a 3-person hearing panel that actually hears the evidence and or reviews stipulated settlements to ensure consistency with the disciplinary standards. And then if the paraprofessional is aggrieved by that decision, it could be appealed to the paraprofessional board, which would handle the appeal within the system, within the bar, before it goes to the Supreme Court.
And no second green box, huh?
The second green box would be take all that stuff out and put the board in there. The board would review.
Right.
The board would be the appellate body, similar to the review department in the attorney discipline system. With
That
the,
would be cheaper.
the review department is a 3-member panel appointed by the California Supreme Court within the attorney discipline system. And if somebody is aggrieved by a hearing judge's recommendation, it goes to the review department. And so,
I guess to me, it depends on on the composition of the board.
yeah, and
Gonna do
we haven't
next
gotten
time.
there yet.
And the board is presumably going to be volunteers, not paid. I
Right.
just wonder if you then go back into some of the other problems that we wanted to avoid.
Okay.
Like you won't create any type of professional adjudicators.
Yeah.
I personally, at this point, do not see these costs as exorbitant because these folks would have other workload associated with other state bar work that needs to be done, either likely in the Office of Professional Competence, which is where I'm thinking these staff adjudicators would be housed.
And I think we've said a number of times, it doesn't seem like there's going to be a whole lot of volume of this.
Well, we don't know, but we do know, like from Ontario, right? 9,000 licensed paralegals and about 550 complaints a year.
Well, that's not so small. What is that, 5% or so?
Yeah.
But anyway, at first, there's not going to be a big volume because there's not going to be that many paraprofessionals. And if it turns out to be more, it can be adjusted, I guess, right? I mean, system could be changed.
Well, we could present sort of two options. One, I guess we have it here. I'm just trying to think if this changes. So if we go with option 2 at the first green box level, the decisions made would be reviewed by the board and approved by the board. In addition, any appeals generated out of that first level would be heard by the board, right? So you're getting rid of the initial appeals box. And you're replacing that appellate panel with the board. So the board has 2 functions: approving hearing and settlement conference decisions made by a staff adjudicator and hearing any appeals. Is that right, Julie?
That makes sense to me. It does depend on how the board is comprised, but
What if for the next meeting, this chart got revised so that the second green box shows it's going to be either a hearing panel, 3-person hearing panel, or the board, and we could still leave a third option, a single adjudicator. Well, we wanted to, anyway, we could. And that would be our choice for the next time when we are deciding what the board is going to be.
Yeah, I think we can revise the chart.
So we don't have to decide.
We have a couple different charts, maybe. One with just the staff adjudicator and the board. Another with the 2 panels and making clear what can go directly to Supreme Court versus not.
Yeah.
The only problem I have with the 2 that you were talking about, Leah, previously, like with Julie, was that then if they appeal, they're appealing the board's decision to that board.
Yeah,
Is that correct?
yeah.
But they are?
Yeah, I don't see that. I see, at the first green box, the bottom green box, hearings and settlement conferences, that would be held by a 3-person panel
Okay.
presided over, who hears evidence. Period. And also, I mean, I guess that 3-person panel could also approve stipulated settlements. Then the second green box, which is entitled Initial Appeal, that would be handled not by either of those two options, but by the paraprofessional board, which would have two purposes. They would review and approve hearing judge recommendations and also stipulated settlements, and they would also handle appeals. So they're not reviewing their own decision. The board is not reviewing its own decision,
Yeah.
reviewing the decision of somebody else. That's what I understood Leah to just say. Is that not what you said, Leah?
I don't think so, because you brought the panel back at a level I didn't think it was. So, all right, the first hearing level, OCTC files an NDC.
Yeah.
In your scenario, who adjudicates that initially? Is it the staff adjudicator number 1?
I thought we were angling toward, in the first green box, option 1, a 3-person panel.
Okay, so it's not, I thought you were talking about an adjudicator. I don't know if I don't know. I thought you didn't want to have a panel, but you wanted the staff adjudicator. If we go with the panel, all right, so then it's a panel, and then what happens? There's no appeal. What happens? That goes straight to the Supreme Court. Let's say there is an appeal.
Yeah, and the court would treat it just like it does attorney orders where there is no appeal.
Okay.
Ministerially. All I'm saying is, you, in the box entitled Initial Appeal, wipe out both those options and put in the paraprofessional board, depending on how we comprise the board, which I guess is happening at the next meeting. I thought that's what you just said, Leah.
Okay, can you repeat it again?
Sure. Okay, so OCTC files a notice of disciplinary charges and seeks disbarment, if you will, of the paraprofessional. Paraprofessional wants to contest that. It goes into a green box number 1. And in green box number 1, there's a 3-person hearing panel consisting of those 3 people, the staff adjudicator, the paraprofessional, and a public member. And the staff adjudicator can be an attorney. And that hearing panel makes a proposed decision. If the licensee does not like that decision, the licensee can appeal to the second green box, and the second green box consists of the paraprofessional board, as we will constitute it at the next meeting. Professional board approves it or disapproves it. If they disapprove it, depending on the reason, it might need to go back for another hearing down below. If they approve it, that's what's appealable to the California Supreme Court. And I assume that as with most attorney discipline decisions, and I could be wrong on this, that appeal is discretionary. The court doesn't need to have a full-blown hearing.
But in addition to things that are appealed, we'd still adopt the model where suspensions and disbarments, even if they're not appealed, have to go to the Supreme Court to be finalized, right? Coming out of the hearing panel, even if there's no appeal, it's still got to go over to the Supreme Court.
Yeah.
Okay. All right.
Um,
So you get rid of box 2, you keep option 1 in the first green box,
right.
and then
You,
then you would retain that bullet.
I would put I would wipe out what's in the box entitled initial appeal.
Yeah.
Wipe out both those options and instead stick the bullet in. The paraprofessional board is going to be reviewing any appeals coming out of the 3-person panel.
But they don't have to review a decision if there's not an appeal.
So you do get rid of that box, that
Yeah.
bullet in the first box. Okay.
Yeah. And yeah, you're right, Linda, if there's no appeal, then the decision of the recommendation of the 3-person panel in the first box becomes a final order, if you will, that goes to the Supreme Court for ministerial entry because there's been no appeal. But it's because the court is the only entity that is authorized to revoke or impair the license of an attorney.
And if it's discipline that is a probation, it just stands after the 3-person hearing panel and no appeal. Or a
Yeah,
reproval or something.
if there's no appeal,
Yeah.
yeah.
Okay.
So what happens at the appellate level? Is the appeal panel going, do they just decide that they would remand it, or would they actually make a different disciplinary decision?
The panel is now the board.
Right, but the board,
Yeah.
okay. So would the board then, they would, if they find for the appellant, does it then go back to the same hearing panel?
No, well, on the attorney side, that's not what happens. So the review
Yeah.
makes an overriding recommendation.
So that's what the board would do. The board would make an overriding recommendation.
Oh, recommendation of the Supreme Court, you mean?
Right,
Overriding decision.
If
basically.
or overriding decision, yes.
Or if it involves something lower than that, then they would
Yeah.
enter their own order.
It
And then
would
you have
stand.
the opportunity to even a public approval can be appealed to the Supreme Court.
Well, I have a request. I still don't, I'm not comfortable with the board being in that the top green box. So for next time, can we have that be a choice that we'll make, whether it's a 3-person panel in that top green box or the board?
Yes. I'll make 2 different, I think it's going to have to be 2 different versions of this chart.
Well, maybe
Right.
not. We got 2
Along the
options there in the top green box right now. So why don't it just be 2 different options, huh? I'm thinking it's going to be easier for us to look at one thing.
We'll figure out the best way to present it in a way that's easy for you to digest.
So let's talk about the next meeting. So we're gonna mock up the different iterations of what we've talked about. I would like, I will want to ask you all about the concern about having volunteers participating in the adjudication process, because I thought we wanted to avoid that, and maybe you're going to recommend that our board is paid, which we'll talk about with the full working group at our meeting in December. But so we're going to come back to these models. I want to talk about the disciplinary standards and how you all are thinking about establishing those. And then we had some outstanding questions around UPL. There was a request that we talk to someone from OCTC handling UPL, as well as someone from a DA's office. So we were going to facilitate that for the next meeting. Does that sounds like a robust agenda?
It does.
And we still haven't gotten to the public record stuff.
Right.
No, okay, so we
And
have.
I just want to point out one thing here. In that blue box, OTCT investigation charging, and then there's the arrow disposition options. The term diversion is used differently by different folks. Over in DCA, diversion generally applies to a program where folks who are abusing substances go. In criminal law, as Ira was pointing out at the prior meeting, it has a whole different meaning. So we need to figure out what we're talking about when we say diversion.
Okay.
In terms,
We'll add that to the
of
list.
public disclosure.
Oh,
Okay. Sounds like we have plenty to do.
yeah.
Yeah.
This
Okay.
meeting's supposed to be over now or at 12?
Yes,
Yes, over now.
Oh,
okay,
okay.
all right. Thank
Just
you.
having so much fun, Ira. All right, we'll see you all in a week.
All right.
All right.
Okay, bye.
Bye.